Hello, hello, hello. It is Friday. We made it. The weekend is here. Holy guacamole. Okay, let me just start out by saying, first and foremost, thank you guys all so very, very much for being here. I wanted to remind everyone that I will be live on Patreon tomorrow at noon. We're going to go over more of the book by Terry Hobbs, Box Full of Nightmares, and I have some stuff I want to show you. I want to get us back on track with that. Um, I'm still trying to figure out how to do um, the Real Housewives of OC because it's starting to heat up. So I want to do that. I think I'm going to do videos and just upload them and give you guys the links. That way, it will probably keep me from being in trouble that way. You know what I mean? Like from getting it taken down or whatever. So I'm going to do it like that. And I still have an extra special thing for you guys over on Dose of Jen Lu. I have Ryan's reaction to episode 5. He told the world. I'm working on that video, and that should be ready this weekend for you all. Then I'll do episode 6 and a reaction, and so on and so forth until the end. Okay. The other thing that I want to address, and I don't want to like belabor the point or talk about this too much, but I do feel like I need to and I want to say something about last night. I think that I have the absolute best chat community in all of the YouTubes. I have never seen anybody ever be disrespectful to me, to a guest, to each other, ever, at all. And I didn't see it last night. I am sorry that things went the way they went last night. I apologize for that. And I especially want to apologize to Mayla's mom for her being called stupid. That was wrong. Told her it was wrong when she did it. I meant it, and I didn't appreciate it. And I'm sorry that happened. I am so glad that you guys all decided after last night to come back. I appreciate that. I appreciate you guys continuing to support me. And I just want you guys to know I'm sorry. We have the best community, and that is what it will be. Where it's not, there won't be a second time. Okay. I'm going to leave it there. Okay. And I appreciate that, Neat Noodle, but at the end of the day, this is my channel. I'm responsible for what happens or doesn't happen. And so I understand that while some guests may have a wealth of knowledge, my channel might not be the best place for them to give out that knowledge. That it's probably better for them to do it over on their channel. And if people want to watch, they can watch. And I'm going to leave it there. And thank you very much, Christina J., for becoming a YouTube member. I'm just saying, in general, Wolfie, there are guests that might have a lot of knowledge, but perhaps they're better suited to share that knowledge over on their channel. And that's how I'm going to leave it. And there we go. So, Wolfie. All right. So, some things happened today that I want to talk to you guys about with respect to Sarah Boone. She is pro saying it up, y'all. There was a hearing today Now, this hearing was really about this motion, a couple of motions that were filed after the fact, they were filed on August 5th by Sarah personally, because that's when her last hearing was. And one of those was her address. She was not getting her notices and stuff from the court because there is a specific address that that's for legal stuff. And then there's her just general mail address, okay, at the jail. So that was one of them. The other thing was with respect to whether she would be able to wear handcuffs. And in that, when they got to that part of the hearing, things got interesting. And so I'm going to show you guys from the beginning, because I think it's all important. And I am, what's going on with Crime Crochet and Coffee? Let me look. Un momentito, por favor. You okay, Crime Crochet and Coffee? You went to the hospital. Oh no. Are you all right? Scott says, question about Boone that occurred to me. How does testifying in her own defense work pro se? Does she ask herself questions and answer them? I think that the way it works is that she essentially just gets up there and testifies. She just has a narrative she's allowed to, that she says. And then I think that when it's the state's turn to cross-examine her, then they will ask her questions. But it's basically just straight testimony when you're a pro se, I think. I'm not sure, but I will definitely look into that. And I have watched several LawTube channels looking for that specific answer. So, and I haven't seen it yet. So I'm just gonna Google it myself. You can't see chat AI from, hold on, let me go on my phone just a second. I pushed unlock too hard. And now Siri is trying to talk to me. Hush up, Siri. I don't need your help. Hold on, let me look. Viewers in the chat are speculating on how Casey Anthony may testify in her own defense and are concerned over her well-being after her recent hospitalization. Oh boy, chat AI, whatevs. Oh shit. Okay. So I got it, babe. I got it. Not that one, another one. All right, hang on. Let me look. Okay, hold on. Let me see what Wolfie has sent me. All right, let's see. Viewers are excited about seeing Cement Shoe's names changed to Wolfie. Some viewers have negative feelings toward her, but others disagree and support her. Someone in chat mentioned Wolfie should have answered some questions differently during her stream. Well, damn, Wolfie, what you did? Chat AI, I'm mad at you, girl. Mad at you. Bruh. All right, so let me get over here to the, I'm going to put the subtitles on as always. And I didn't mean to push that. The audio is what the audio is. We have the same cameraman and, or camera person, I should say, because I don't actually know who is operating the camera. But I would like to please request for the camera person to, you don't need to zoom so quickly, okay? You're not filming the 8th installment of the Blair Witch, okay? Please, for the love of Pete, slow your roll. It's too much. You need to work on your what's the word? Smooth zoom, okay? It's not a race. Calm down. All right. So, all right, here we go. Is everybody ready? Because it's a doozy. And we'll get to it. I'm just going to shut up and let you guys listen. All right, here we go.
Madam Clerk. Dave Ketcher on behalf of the state.
William J. for the state.
Ma'am, good morning. Can you raise your right hand? Madam Clerk will swear you in.
You swear or affirm that the testimony you give shall be the truth, so help you God. Yes.
All right, ma'am, good morning, rather.
Hold
Can you
on a
state your
minute.
full name and date of birth for the record for me?
This is not working for me. Just give me 1 second. I don't like this. There's another. Don't you worry. There is another one, and we will watch a different stream because this is terrible. The audio was not like this when I watched it from Court TV earlier. So give me just a sec. Here we go. I guess the audio is the audio. Oh, I'm sorry, you guys. I hope they get this fixed in time for trial because this is too much. All right.
We had a hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right. I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy of that order. On May 25, we had a hearing and an order was entered and a notice of hearing was set. That order was hand-delivered to you. Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you had placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also a certificate of service providing you the Justice Administrative Commission's response to motions seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with address to you, your inmate number, FDC Dorm B, P.O. Box 4970, I apologize, P.O. Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th?
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address. We've been addressing P.O. Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was sent that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so
Okay.
for receipt.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the PO box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to PO Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
And it has begun. Now, I want to point out this to you guys because this is going to be an underlying theme with this whole situation, with this entire hearing. Okay. Sarah will make a statement, and when asked clarifying questions or asked specifics, she doesn't have them. I'm trying to be as tactful as I can because I'm trying to be it's hard for me because Sarah Boone, just fundamentally as a human being, irritates me. She's just not my cup of tea. But I also understand that she has rights. And I also understand that George had rights, and that now she ended his life. She took his life, and now she has to pay the consequence. And I'm anxious, just as all of you guys are, to get this show on the road because his family has waited a long time. And all of this, monkeying around and, wasting time and asking questions that she's that kid in class. We all had that kid. You all know who I'm talking about, who your teacher would be giving the directions for an assignment and would be very thorough about each and every direction. And all you wanted to do was just get started and get it over with. And there's always that one kid who raised their hand to ask a question that they'd already the answer had been given in the directions. And they would do it over and over and over. That's Sarah Boone to me. That's how that's how I feel about her. So that is, you were that kid, Neat Noodle. See, I could be patient with it when I was in elementary school, but when I got to high school and the teacher was about to let us go and that kid would be asking the questions, that's when I'd get up. That's when I'd be like, nope, I can't. Let's see. Tess Mack, thank you. She wrote, with a member for 15 months, wrote, what would I do without you and your interpretation of everything? Boom, Jen Lu. So thankful to have this community of fantastic humans. Love yas. Thank you, Tess. Loves you too, babe. Thank you so much. All right. So that's what the overriding theme is going to be. And I appreciate you too, Tess. I really do. I appreciate each and every one of you guys. let's get started. It's already going swimmingly. Sarah's very red in the face, so here we go.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can't tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner, Prison Break Investigation.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane a copy of our, the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness lists, also proposed jury instructions, and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question.
And I
Okay.
have a copy for defense
Okay, very good.
as well.
Debbie Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
Yes. And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses in trial. I don't have an order or.
It wouldn't be an order, it would just be that first document you read, reference, the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone.
Yes, they're broken down by folders.
And the folders, or the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to, again, they're tended to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Castore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay.
What-
Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't
What does
know.
it say?
I don't know. I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what for the
to.
most part means.
Okay, here's the problem. And Sarah talks about this a lot. She talks a lot about, effective communication. She does not have what I would describe as effective communication because you see she's busy here with pen and paper. She's provided pen and paper in the jail when she's looking at her files. If it were me, right, and I wanted to convey to the judge, listen, this is what's going on, and I need to see these, I would need to tell you what's happening, I would have written a list. I would have said, listen, this is the main file, and then the subfolder, and then the subfolder, and like that. That's how I would have done it. And I think, that would probably be much better, and much more of an effective way to communicate because quite frankly, the judge is not allowed to see this evidence. He doesn't know how it's let me put it a different way because saying he's not allowed to see the evidence is not 100% accurate. And you guys know how I feel. I like to be accurate. When Sarah was given her discovery, the judge could have no part in viewing the discovery. It must pass from the state to the defense. And in this case, the defense, because Sarah's pro se, is Sarah. He's not allowed to get in between it. So when she is trying to explain to him what it is that she cannot open, he has no idea what she's talking about because he hasn't looked at the thumb drive or the the USB drive. He has no idea what she's talking about. And so it's not an effective way to communicate, Sarah, for all of your rambling about effective communication. But here we go.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
Okay, all right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio-only files.
Okay, all right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other?
Okay, so Nana Banana says, anyone know how old Sarah is? Yes, I do. Sarah is 47. She will be, wait, she's born in 77, in October of 77. So she will turn 47 this in October. Yeah, because I will be 48 in January. I don't want to talk about it, but here we go.
Other concerns, ma'am, as to the items identified in this notice?
Oh,
Until
wrong
I'm
thing.
able to open them and see them, no, I do not.
Sure, okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her? If you know?
9 a.m.
Okay, all right. I have had the opportunity to have further conversations with Major Mohammed at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
Literally
So it was
just what he
Hall,
said.
H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you.
See, this is why, again, there continues to be ineffective communication and miscommunication. That was a very simple question. Who did you speak to yesterday? Not who sent the person to speak to you. Who, sound like an owl. Who did you speak to? Lord.
Do you know Ms. Hall's first name?
I don't know any of the officers.
Okay. All right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can, yes.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No, Your Honor.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You had the smaller one, which was everything you digitized from the 2 boxes, and then you had the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has the physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes.
Okay. If you want to, can he be released, ma'am?
I guess I'll see you at 9.
Okay. Sir, if you could endeavor to do that today, I would greatly appreciate it. All right. Thank you very much, sir.
Thank you.
Now, I know this might be small and it might sound nitpicky, but please be patient with me. Bear with me. Sarah, when the judge asks you if he can be excused or released, you need to answer. They're making a record. Ugh, she just frustrates the shit out of me. All right, here we go.
All right. The next matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Courts have the opportunity to review that motion.
Okay, what I want to do here is let's go over to the clerk's website and let's review if we can. Let me see here. Here it is. Let's review this motion because something is going to come up and I would like for us to go through the motion. So when this thing comes up, we'll know. Okay, wait, this is not what I want. Hold on a minute. I clicked the wrong thing. This is from today. Hold on. Here we go. Let's see. Well, let's read the first motion that she filed. Not this, not that, this. All right, hang on. So this is, hold on. Let me make sure what I want. All right, this is her argument why she should be allowed to have her digital copy or her hard copy. So basically, let's see. She cites some stuff here. Comes now. She explains what discovery is. She cites Brady, which I want to, let me see what she wrote about Brady. Can you guys see this okay? All right, let me make this just a little bigger for me to see now. All right, let me see what she writes about Brady. The government is obligated under Brady and United States versus to disclose information in its sole possession that is material to the issue of guilt or innocence. The government places heavy reliance on the cases that hold information is material. If there is reasonable probability that had evidence discovery been disclosed to the defense, the result of the proceedings would have been different. Okay. Any documents or requests made intentionally and available to the defendant through discovery and the federal rules of criminal procedure are in direct violation of the defendant's due process with prejudice and shall not be denied, restricted, or deferred upon request by the defense. By doing so, this constitutes intentional misconduct warranting sanctions. She's quoting the Bouvier Law Library. This is what she says. This is her justification. By the court only providing digital USB discovery to be viewed solely on the laptop provided by OCCD and restricted to select times during the day only, motion for extended times in process. Without the necessary hard copies, the defendant is unable to A, review, research, investigate, build her defense at any time. Numerous hours are ineffectual and wasted by not having access to the laptop and by not having the original hard copies available to use physically during the laptop's closed hours. B, write notes, remarks, interpretations, explanations, make recordings of any kind. C, transport to meetings in any location, including to the courthouse. D, make copies for distribution or any necessary presentation in court. Due to the court's error of not communicating with the defendant foremost to avoid present circumstances and the jail prior to the implementation of the order on June 28th. Y'all, she is still salty about that order. And after the defendant's July 8th, 2024 letter questioning the location of her promised hard copy discovery, 2 boxes A, B, as a direct result of her extended waiting period for delivery by the court to expeditiously review, research, organize all contents, and attempt to prepare all pretrial motions as ordered by July 22nd, 2024, the defendant is now forced in this abrupt manner to only receive and be restricted by the court USB copies of her discovery. It is an obstruction of justice to withhold the defendant's original hard copy discovery that has been compiled for ongoing 5 years to properly, fairly, physically construct her rightful defense at all available times necessary to her and on the sole independent decision of the court as the defendant. 1, did not ask for or suggests this USB only option. 2, was not included in any decision-making, collaboration, or equal agreement for USB only format to be received, was never advised by the court prior to implementation of only receiving USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. Time, consideration, and inclusion could and should have been made on the court's behalf to prequely avoid present disadvantaged circumstances, and the defendant would not be deprived of her due process and equal opportunities to correctly, fairly represent herself and succeed futuristically. Wherefore, Sarah Boone, oh yeah, okay. This is just where she swears it in. All right, so let me go over here. This is address correction, freedom of movement. This is the one I want. Okay. So, what Sarah is failing to understand, I don't know if she is failing to understand that intentionally, failing to accept what the situation is or what, but the fact of the matter is, Ms. Boone, typically you are not included in jail policy as a inmate at the jail. They don't typically sit down and have meetings that include inmates as it pertains to policies at the jail. So there you go. Yep, Sarah Boone. All right. So there was some confusion on the part of the judge. And the only reason why I want to read this is because while I believe the judge's interpretation of what Sarah is asking for is correct, she gets very confusing. So let's go to the evidence. Let's see what it is that she wrote. Okay. Comes now Sarah Boone, pro se, indigent defendant, respectfully requests from the court to be unshackled, unhandcuffed, and allowed reasonable freedom and movement to function accordingly, equally, and comfortably while utilizing the courtroom. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of the defendant's hands, and as a whole to freely, properly, successfully accomplish any task needed for. Prior to the entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographers, general public, witnesses of the court, as well as vigilant armed deputies also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled, unhandcuffed. Sarah Boone, I hate to be this bearer of bad news, but this courtroom is no different than many other courtrooms across the United States of America. And we have seen defendants, one defendant leapt over the counsel table and attacked the judge. We've seen with Taylor Shabizna, she attacked her attorney physically. It happens. Okay. And even under the watchful eye of all these people. In fact, in all of those cases, it was caught on film because there were cameras in the courtroom. So that's not enough of a argument, but okay. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested, respectfully seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. So that is what she's asking for. Let's see what she will get.
Meeting with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay, so ma'am, we're gonna have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions. We'll cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay,
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness, state.
State will call Gavin Lowton.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LWTAN.
All right, thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff on
And to what area of the sheriff's office are you assigned?
court security.
And how long have you worked that assignment?
Over 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge of it.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be here shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me, it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Lowton?
I do.
Go ahead.
First off, in your inputs research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor?
I'm going to sustain the objection. Ma'am, you have to ask 1 fact per question.
Okay.
I am prepared to give her the dates. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At the
court?
jail, yes.
Who is your contact, please? I've never missed a date.
This is the database that I got this information from.
Do you know when it was last updated?
I cannot.
Okay, so do you know how, I have never missed a court date to the present date. I don't know specifically what these 3 dates are for. in order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
For September 15th, 2023, it is Corrections Officer Portia Hines,
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay,
And if you would like, I can read her comments in her report.
sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal Hal Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what you're hearing.
Okay,
Second one, it'll be Officer Christy Green.
and what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's gonna be October 16th, 2023.
Okay, and I'm sorry, the name?
Green, Greene,
And what was the first initial, please?
K,
Greene,
yes,
10/16/23.
yes.
Okay,
And the third one is January 28th, 2021, and the officer is Jasmine Scribner, Scribner.
what are the comments, please, for Green?
Approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward at the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28th?
Approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay, so
Okay, after we hear this little exchange, I'm going to show you her docket. Okay, so we're going to talk about this. Hey, T, good to see you, babe. All right.
trying to figure out how I know all three corporals and the sergeants, so I've never refused court. There's no reason for me to want to refuse court.
I'm gonna object this to answer.
Unless it's any objection.
So the domestic violence, the original was dropped. I was never charged with that.
Object as to relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act, it just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
Your
It
Honor,
said,
Your Honor, I'm gonna object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm gonna object this to the form of the question. It's not a question, it's a statement.
Sustained.
Okay, kiddos, what we have here is a failure to understand proper court procedure. Here's the deal. You got to ask a question. It's not a debate back and forth. You ask, he answers, the end. And Sarah is not properly prepared for this. Now, would you guys like me to, I won't be able to find this case, I don't think, because It won't be part of the clerk. It'll show that she was arrested for it. So it won't be on the Orange County clerk's website because obviously she wasn't prosecuted for it. Right. And Sarah also doesn't understand the difference between charged and convicted. Right. You were charged with that. You were not convicted of it. But let's keep going.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
Yeah, but this is not when you would answer. Okay. You don't answer your accusations at this time. I mean, this is what baffles me about Sarah Boone. She had enough time and forethought and intelligence to write some fairly well-written motions. Okay. Yet she didn't. She's so focused. This is where Sarah gets in trouble. She's so focused on arguing her point about wanting the physical discovery, the hard copy. She doesn't want to just have it on the laptop, that she missed the fact that there's going to be a hearing today and they're going to be arguing her motion, and she didn't prepare for it. Now, to be fair, obviously she is not an attorney, but at the end of the day, Sarah, you got to work with what you got, okay? And you need to get it together, lady. Like, prepare. This is not the time for you. This is your opportunity to question the state's witness, okay? Your turn to defend yourself. Will put yourself on the stand. You can testify. It's your hearing. Bruh. All right, here we go.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that is in your history.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The rest is on your record.
But the charge for the domestic violence is not on my record.
No, you were never
Just
convicted.
ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
Shockingly, criminality, nobody has taken her up on her help wanted flyer, although mentor lawyer did go and have a few visits with Sarah, and it was he's not representing her, but everything that they talked about, they agreed that would be under attorney-client privilege. And I need to go and check, because at one time he did have a video up discussing what he and Sarah agreed that could be discussed on his channel about that visit. But I'm given to understand that since then he's taken it down. And if that's the case, that's really a shame, because, I think that if he took it down because he was getting a lot of flack for it, I think that's a shame. I think it's a shame if he took it down, period. But I'm given to understand it's because he got a lot of flack for it. And I think that's a true shame, because he does understand the law. He's very good at explaining it. That's why I go to his channel, because I can understand what he's saying. And he took an oath as an attorney, you guys, and he believes in upholding the Constitution of not only the United States, but also of Florida. And Sarah does have the right to a fair trial. And he felt like just giving her a little guidance. I actually think that was an admirable thing to do, given the fact that he knows how the public is going to perceive that. Look what happened with Tellini when he represented Letitia. You know, it makes me sad. It makes me sad if that's the case. All right, here we go.
For the three supposed noncompliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it
Your
a,
Honor, I'm going to object to the form of the question. This is a statement, question.
Objection is sustained.
I guess I will provide information to you for the noncompliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to ask and answer.
Sustained.
Sarah, for the love of Pete, you were charged with it. You were not convicted of it. Gina, did I well, did I answer you, Gina? I'm sorry. Oh, why didn't he? Oh, yeah, I did. I answered you in the chat. Oh my God. Maybe I should just end this live right now. I'm sorry. Here we go. Sarah doesn't understand the difference between a charge and a conviction. And the fact of the matter is that when they're discussing security of a defendant, particularly one representing themselves. See, now this would be a whole different matter if Sarah had an attorney, right? If Sarah had an attorney, what the attorney would do is, make sure that Sarah entered the court before the jury, was always seated, that there was a privacy skirt around the table so that the jurors never saw her shackled. That's standard protocol. It has been standard protocol for a long time. They would also motion the court, and the court would grant the motion to allow Sarah to wear street clothes. They're going to talk about that in a minute too. But if Sarah wanted to, she could make a motion in court right now and ask that at these hearings that she be allowed to wear street clothes because they are open to the public. She could ask, and he probably would give it to her as long as she, behaves. But the fact of the matter is when they're talking about security, they're going to pull your record, Sarah, and they can see every time that you've been arrested and they can see what you've been doing in the jail.
Okay, I will, do I provide this information to you?
You can provide it to the state.
Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be restrained.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Right.
And it is now 2024.
If the state wanted to, they could object because
And you're
that's
going solely
not a
off of,
question.
What, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped? that I would not be able to be unrestrained.
Correct, your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
Oh, boom. There you go.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped, I'm just telling you what the history is. So,
And you can still apply it even though it's not been,
right, it's in your history.
okay. Thank
Look, Sarah, it doesn't matter what you haul your court, what you bring into court, right? He's made his decision. He's testifying for the state. The state opposes it. They don't want you just, loose, as it were. Okay. That's just, it is what it is. Now, we're going to pause it right there. I'm going to take you over to the clerk of courts. Let me share the screen because I went and looked this up. Okay. Now, while obviously it's different, I can't see what the comments from the jail are. I can definitely try and verify these hearing dates, right? Oops, wrong thing. All right. Add it to stream. All right. Let me zoom in for you guys. Hold on a minute. Let me zoom in for you guys. All right, now let me add this to the stream. All right. So the first date going in order that he gave them would be 9/15/2023. Canceled. All right. So I don't know where they're getting that she didn't go, that it was canceled. All right, 10/16/2023. There's no hearing. All right. And then they have January 28th, 2021. Oh. There's nothing in January of 2021. There's only one. There's one in February. So I have to say, after doing my research here, I'll even go up to this, the docket entries. All right, those are hearings. So let's go September 15th, 2023. Let's scroll up. All right. Scrolling. Hearing canceled. So it's going to be the same on the docket entry. There's nothing there. So I honestly, Sarah is right. Oh my gosh, Lisa. Look, Lisa's signing me up for things. If we get to 100 likes, Jen Lou will do an impersonation of Gypsy Rose and Ain't B having a conversation about the day's fire. Oh, so, I mean, and when he said that she refused to come to court, I'm not going to lie, you guys, it did give me pause. And I'll tell you why. Because that is the one thing that Sarah was vehement about in each and every single one of her letters with respect to her attorney Bankowitz. She was huge mad that he waived her right to appear without talking to her because she didn't want her right to appear waived. She wanted to be in court for each and every single hearing. She didn't care what it was about. She wanted to be there. And so, it's problem, that is a huge, that's a problem. I mean, I feel like, I don't know if there is another, I mean, he clearly got that arrest correct, but let me look at something really quickly. Let me make this not so big. Let me go back. I'm going to stop sharing this and start sharing the, I want to look at something while this plays for you guys. All right. Oh, you have to add it to the stream. Come on, Jen. All right, here we go.
Thank you for the information.
Any follow-ups, Dave?
No, Your Honor, fine.
Thank you, sir. Anything else, Dave?
Not from the state.
Okay. See Deputy Barnett here. Could you come up, sir?
Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Chad Barnett.
Not your date of birth. Sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm Deputy Sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's a box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden against, and gives the ability to be moved on the ground.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with two straps on the leg. There's a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of the use of the device. It's a two-step process, so there is no way for it to accidentally be set off. It has to be hit two separate buttons for accidents. If it had to be used, it would cause a shock to the location on the calf, causing great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow with another use, response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it's at a level 3.
And what is a level 3?
Level 3 would be failing to follow directions and stuff like that. If we asked her to get up and move or not, or follow off order, we could use it. Most likely in the courtroom, we use it probably at a 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. We take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to the leg.
And it's a one-time waiver?
Each day you have to resign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes,
and remove?
yes.
Thank you.
Any follow-up?
Nothing to say.
All right.
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were wearing a leg iron, your hands would be completely free. The sun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the sun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up statement?
No, Your Honor.
All right, can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right, thank you, sir. State any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion.
Okay, so I did find this that I wanted to show you guys. I would imagine that this is something similar to what she's referring to, this letter that she's talking about. Hold on, I got to remember the right tab. I think it's this one. Okay. All right, here we go. So this is the there we go. That might be too much big. Okay. So basically this is, the charge was battery by strangulation, dating violence. Sarah's the defendant. It says comes now to state of Florida by and through undersigned assistant state attorney states that 1, from the investigation which has been made, it is the opinion of the writer that this case is not suitable for prosecution. This action is taken to clear the records and to release the subject's bond, if any has been posted responsive to the above charges. If in custody, defendant should be released. Now, what I will tell you is when you go back and look through the docket entries, you can see them. You can see that she filed indigent in 2018 and that there was work being done on the case. There was a demand for discovery. So I don't know what caused them not to prosecute, if it was because George decided that he didn't want to cooperate. I don't know. It isn't noted. So there you go. But she was charged, and it was a felony. All right, here we go.
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the local court has to consider with regard to your request and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion.
That's what you
So
wrote.
just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel,
boy.
because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. But you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom.
That's literally verbatim, a quote, exactly word for word what she asked for. And what he is trying to ascertain from her, first of all, what she's talking about and what her motion says are two different things. Okay. She's actually trying to ask so that when she comes to the hearings, that she can be unhandcuffed, that her wrists are not bound. That's what she actually wants. What she put a motion in for, and this is where this gets complicated when you're pro se, is she put in a motion. What she was actually asking for was at trial. So the state responded to the motion by bringing in the person who runs the show as far as court security goes, and another officer who also is in charge of the stun, whatever it is, collar shackle thing. Okay. So that's where this is where ineffective communication comes in. And let's just keep listening.
All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I just read. So if you would like to clarify before me now at this time, you can, as to what it is that you're asking of me.
Yes, handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
Hold on a second, because I want to answer this. Darrell Brooks did not have free reign. He was shackled. He also had a shock cuff on his ankle. And the only reason why I know that is because he complained about it. He wasn't free to move. He had to, and that's why that's why they have that skirt around the table, the defense table. And that's why when he did any of his questions, whether it would be direct or cross-examine, I don't think there was any direct, but you take my meaning. That's why he stood at the defense table. He didn't even move to the podium. He was shackled. They don't allow prisoners, they do not allow defendants typically to be unshackled, completely unshackled. They didn't allow George, That's another thing, that Wagner, that trial should be coming up soon too, his dad. But they don't typically allow that. What they have found, what they have agreed on with the Supreme Court is that it is prejudicial to the jury to have a defendant sitting at the defense table with, shackles on their legs, handcuffs on their wrists, that it implies before the jury has even heard one scintilla of evidence that they are dangerous and that it's prejudicial. So what they've done is they have made concessions and changed protocol so that the jury doesn't see that, and the jury therefore is not prejudiced. So there you go. That's the answer. All right, here we go.
Is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that was why I was trying to be transparent and up forward by doing so now, to make the court aware that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay. Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial.
Okay.
Yes.
Well,
Is there anything else
Hold
ma'am,
on a
you would like
second.
to tell me with regard to?
you're not going to be sitting there for trial, Sarah. You're going to be at the defense table. I'm pretty sure you're sitting in the jury box right now, babe.
What
Okay.
we're seeking in your motion to be
Granted.
hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial. Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank you. Anything else you'd like to tell me?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position that she should not be unshackled, but you've also heard from Deputy Barnett, who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at the counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled? Or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowen identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. The privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, you're just address all the concerns, which is the court's plan.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was.
Oh, you're welcome, Sherry. No worries, babe.
Who've been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and
Hang on, I want to answer this really quickly. Jenny B says, I think she may still get a continuance. Well, she hasn't filed for a continuance, so unless she makes a motion for a continuance to extend her time, the trial is going on exactly when it happens. It's scheduled for October 7th. It'll start October 7th. The judge has been very clear that the dates are what the dates are. She has to ask for it. And I haven't looked at everything that she filed today. I just wanted to read you guys the letter at the end of this, that she wrote to the person at the jail. So, yeah, there you go.
There was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety.
Oh my gosh. Can you imagine if she had Judge Bev? What would they do? Because Judge Bev loved a sidebar. How would Boone handle a sidebar if she's, that's an excellent point.
Found that the trial court's utilization of the stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and being seated at counsel's table for any motions moving forward?
I object. Let me tell you why I object. I object because of the way that the view of the courtroom has gone so far. With the counsel's table over there, we will not be able to see Sarah Boone, and that is why I object. I would like to be able to see her. I want to see. Truth be told, can we just move? I'll tell you what. I will withdraw my objection if we can agree to adjust the camera where we have a better view of everybody in the courtroom, i.e. the judge, the prosecution's table, and the defendant's table, because I would like to see all the things. That's my objection. Please consider it. Thanks. Bye. Here we go.
No, we defer to the court and the sheriff's office, who's in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so now, the court's gonna grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table.
Oh,
Okay?
look,
You may
the
still have your leg restraints
cameraman
on,
learned
but
slow.
you'll be hands-free. For the purposes
Zoom.
of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the council's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Thank you, Teacup, for allowing it. I appreciate it.
The other item I have.
Agreed.
Yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have.
I agree. We would need, yes, sidebar. We want to see all the things, all of them.
Clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes, sir.
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. You can take those off.
In
when
advance.
she gets up here.
Yeah, I agree. I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg.
The stun cuff. Thank you, boss lady. Best channel. I adore you, Jen Lou. Thank you so much. I appreciate that, babe. I adore you guys too, and I adore you. Thank you so much. And thank you to Neat Noodle, who gifted a word case studies membership. Thank you, thank you, thank you. If you got it, be sure to thank Neat Noodle and thank MK Land because he gifted a membership as well. Thank you guys both. Very generous. I appreciate that very, very much. I don't understand something like this. This situation is very busy. This is a lot of things to be carrying on your person at one time. I don't know. I would find it very difficult. I'm easily distracted though.
Identified by Sergeant Barnett, you're gonna have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It
just?
is under your clothing as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's gonna have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs,
Yes,
okay?
thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that, I saw the confusion based on my experience and how it's done. We cleared it up.
Thank you. Now, ma'am,
I have to say, I have to stop right here because I think this is important to note, and I don't think we do this enough. But I really have to give props to this judge. It's not that I dislike Judge Wooten. I think Judge Wooten did a good job. What I like about Judge Kranick here is that he is to the point. He is thinking ahead, which is he recognizes that Sarah does not have people around her that would bring her clothes. So he's already thought ahead of that. And I have to be quite honest with you. While I understand why the judge made the decision that he made with respect to forfeiting her right to the public defender. I think he did it with a lot of forethought. I don't think he took the decision or that order lightly at all. I think he felt like it was a last resort because I really do feel like if he wouldn't have done it, I think we would still be in the whole, I'm trying to find a lawyer, be getting letters, all of those things. We wouldn't see it move. There has been more progress in this case since June 28th, 2024 than in all of the years prior. Oh God. Okay. So I've got to do an impression. Well, let me think about that. I mean, I'll do it, but let me think about what I want to say and I'll do it at the end after this is over. How's that sound? Okay. All right, here we go. It's almost
That doesn't
over.
mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand. And you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy, or is it?
That's what he literally just said.
You can do it faster.
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the
Hey,
courtroom.
Jojo, good
so
to
that
see you,
there
babe.
will be a deputy for basically your disposal will be seated closer to you. So if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State, anything to clarify?
No, Your Honor.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail cell email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of the laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that will be hand delivered to Ms. Boone and e-filed to the state today.
I think
Is there
Brian
anything
is
else
going
stated
to,
that
hold
we
on
need
a
to
second.
address?
Let me push pause.
No, Your Honor.
Okay.
I think Brian is going to be called as a witness because he was there. So I think he's going to be called as a witness. And since he isn't a victim or isn't considered under the, because, under the circumstances, he's not a victim. So usually they don't allow witnesses in to attend the trial until they've been released from their subpoena. So we'll see how that goes. So all right, here we go. That's all I wanted to address really quick. And I can't imagine that her son would be in attendance. I think that would be a horrible idea.
Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Here we
In
go.
regards to the status reports you were just speaking about regarding them providing me with a laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, my concern was they're not stating what it was that I looked at for how long and
I don't know that
anything.
they're going to record that information on the protocol, ma'am.
Hang on, you guys. Lisa, thank you so much. Jen Lou, you are the GOAT. I don't know what sound a goat makes. And I appreciate you, EXO. Thank you, babe. I appreciate that so much. And I appreciate you. It was very generous. Thank you so much. No, I know. I just, it's been a long couple of days, Michelle. I'm like, sarcasm was just, I don't know, you as fluent as I am in sarcasm, how I wasn't able to pick that up. I apologize. I'm sorry. I apologize for that, babe. All right, here we go.
just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail.
Bless it. He's
That's at paragraph
explained
5.
this to
State's
you
physical evidence will be
87
reviewed with the state and
times,
the defendant
lady.
on September 3, 2024 at 9 a.m. at courtroom 12A, Orange County Courthouse, and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Yes, ma'am. I pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents.
Got
We
you,
no longer
Michelle.
need
Thanks,
that hearing
babe.
on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problem. It's the Miami Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is
Oh, I'm going to look up that case.
I'll be able to hand deliver you the one today, changing the Orange County Jail and providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank
And
you.
that'll be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane?
No, ma'am, the USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, no.
Ma'am, is there anything else?
I do have this. I made a copy of it for you this letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives. And just as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, you could give your letter to the deputy. We will file that in the court file.
We finna read it.
Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on media request, or prevent media from being at the September 3rd discovery viewing hearing, will address your concerns as identified in this letter, and have a representative from the jail, be it Captain DiGiovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence hearing, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th. Okay,
They've
all right.
already set.
Any other questions?
Oh my goodness, Sarah.
No.
Okay, I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also
Good
send
night,
you a copy by
MK.
way of mail. It was
Thank
already
you
mailed.
for gifting a membership and
Okay,
for
we're gonna
being
mail
here. I
you a copy as
appreciate
well, ma'am.
you.
Today, I'm
Let
going
me
to give this
push
to the deputy
pause. That
provide
was
to you. This
rude.
is the pro se packet that
Let me say this where people can actually hear it. Good night, MK. Thanks for coming and thanks for the gifted membership and thanks for being here. I appreciate you. Okay, bye. All right, I'm going to push play again. Thank you, MK. I appreciate it.
the JAC attorney made reference to on our hearing on August
She's
5th.
getting her package,
Yes,
y'all.
thank you. And then also the public defender's office, you said would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your
All
Honor.
right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
All right, send her back to the jail. All right, so let me read you guys this letter that she wrote to the jail right quick. I really don't understand what her issue is with this USB drive. And you know why? The reason why is because those you can see who's you can see who's accessed them. So I don't understand why she's so uncomfortable with the USB drive, which, by the way, she says you can't even access half the stuff. And it doesn't have any, if she can't access it, it has nothing to do with the fact that she has a quote unquote basic laptop. What it is she's probably opened, there's probably, what's the word I'm looking for? Duplicate files. So the original file and then a file that they've been converted. And so what she's probably done is she's just random clicking. And so it's not, I don't think it's laptop error. Meaning if she had a better model of laptop, she'd be able to access those. Formatting is formatting. It won't work. So I think that's the issue. But let's see what she has to say about it. And then I will give you guys Gypsy and Aunt Brenda. I haven't done Aunt Brenda in a long time. I hope I can remember how to do it. All righty, here we go. Oops, that's not what I meant to do. That's twice I've done that. All right. Captain DiGiovanni, thank you for your timely cooperation and assistance. I wonder what these S's, how they're slanted in the way that they are. I wonder what a handwriting expert would say about that. I wonder what that means. Anyway, let me keep going. Thank you for your timely cooperation and assistance in me receiving my laptop yesterday, 8/6/24, and to discover USB drive supplied by my investigator. I am attempting to fully maximize my opportunities available from OCCD to thrive in my forced position as court-appointed pro se defendant and the success of my case. I want to excel in my present circumstances by attempting my best and have been since day one of my incarceration, ongoing 5 years ago. As you can imagine, I do not want to be here any longer, ever. With the hopeful, effortless cooperation and attentive care from yourself and OCCD, I believe I can achieve more efficiently, effectively, equally, so I am able to plan my very overdue exit in the very near future. I have been instructed to contact you directly for the listed questions and concerns to hopefully remedy or provide further insight for completion of, so there is a universal understanding to enable me to produce greater, faster results and work product in my case and defense. Thank you in advance and profusely. From now on, I think in the chat, I'm going to require, I've said this before, but it bears reminding. I would, I'm going to request that anytime you guys thank me for anything, that you thank me profusely, please. Thank you profusely. 1, laptop times. Extend from 8 a.m. to 4 p.m. to 7:30 p.m. through to 10 p.m. I am willing and need to vigorously work on my defense as often as possible. I do not think I should be restricted to daytime use only. After 4 p.m., I do not have access to the laptop, which equals 0 work product in progress. The building of my defense is halted for 16 hours until the next morning. Request, extend times to use by 2.5 hours in the evening. USB drive security. As stated in court to the judge, I do not feel comfortable in handing over the entire contents of my case to the miscellaneous officer in the dorm for the day. See, this is where Sarah goes wrong. That sounds, oh, Sarah. You know, just because you can use big words doesn't always mean you should. To the miscellaneous officer in the dorm for the day, all of my information is highly confidential, and I'm trying to avoid further leaks on top of the already recorded jail phone calls, visitation names and details, my inmate interaction, meals consumed, etc. As a concerning example today, I returned the laptop and USB drives together yesterday. I received back the laptop, which is not charged at all for instant use, and the USB drives separated with the protocol security paperwork removed I needed, and then both bags sealed. Another example, I went to pick up everything in the morning, and the officer removed both US drives from the bags before giving to me. Who is in control of the laptop and my 2 USB drives when I return at the end of each day? Where do they go? How are they secured? Why are the contents being removed and opened? Because they're handing them to you. I guess what she's upset about is she wants the bags handed to her, not the drives. As I said, I do not feel secure in this process, if there is one, and it is vital to me that OCCD handles with priority, safety, security, and care when asking any officer anything pertaining to the laptop and drives they do not know and become agitated with me trying to ask and figure anything out. Request, allow me to keep only the 2 USB drives at my bunk after returning the laptop to keep in my secured locked drawer each day. Hopeful evening. Classroom. This room is unoccupied for the majority of each day and an available, close, undisruptive solution for me to achieve privacy for reviewing and listening to my confidential case documents. The classroom is also in direct, continuous, effortless view of the officers at all times. Request, permit me to access to utilize a table in the classroom. Sorry, guys. Excuse me. To view and listen to my discovery on the laptop when not occupied and is in direct view of all the officers. 4, earphones, headphones. As said, my discovery contains a large amount of audio to be listened to. If you will not permit me access to the classroom, I will need listening abilities with earphones or headphones over the ever increasing noise level of the dorm. These are also a must when the dorm is on lockdown and quiet so no one is able to hear. Request, provide any kind of earphones or headphones. 5, internet with limited access and restrictions. I need to research heavily my defense, all of it, locate witnesses, any experts, the clerk's website, correspond with the judge, my defense team, anyone affiliated or may be with my case, forward note motions, other important documents, everything I need to educate myself on about being pro se, etc. Please understand, I cannot complete any of the aforementioned without internet. The basic laptop provided is only for viewing my USB drive. There is no other access. Request, grant me access to the internet with appropriate parental controls in limited access with restrictions. B, word program to type any note, motions, make notes, lists, anything I need to document and record for future reference or sharing with potential team members. I need to be able to open and create a document, save worked product information, attach text or PDF documents, create to email if granted, print needed documents or discovery pages for mailing. Oh my gosh, I'm sorry, you guys. For mailing, sharing, presenting, or distributing. Request, permit access to Word program to use fully, properly, and progressively. Telephone access. As you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular normal phone to make any and all necessary calls for my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly diminishes most, if not all, my opportunities to properly prepare. Request, permit me access to a regular normal phone to communicate reasonably with the parties in my case and any new futuristically to be affiliated with. This is about her discovery hard copies, and she got that. I am diligently working on what I can with what I have, laptop 2 USB drives, and severely hindered in real progress without my request, especially needing to access the internet and a normal functioning telephone. Becoming pro se defendant was not my choice. I am already trying to overcome extreme circumstances just in my life of incarceration, and now in addition, being forced by the court to represent and defend myself in my criminal case. Extreme has progressed to extraordinary. Please understand my attempts are always in good faith, where I am simply trying to complete these tasks needed to suppress my difficulties and achieve overdue success. And finally, and I cannot do it without you and the assistance of the Orange County Corrections Department. I thank you, everyone, for your patience and await your response for needed collaboration and conclusion of my request, please, and criminal case. I've notified the judge also with a copy of this letter, so he is aware I'm in the process of trying to receive these must-haves and that I need further guidance and answers from you first. From there, I can create all motions that may be necessary for access and completion. This is important, Captain, and time sensitive, as my proposed trial date is on October 7th, 2024. As of this letter, I have only 59 days for the completion of my defense prior. Please understand the importance of your timely attention and response. As said, I cannot do this without you and the help of OCCD. I am beyond grateful. Please notify me as soon as possible, please, about any motions I need to file for my request to be granted. Thank you immeasurably, sincerely, Sarah Boone. I spoke with Sergeant Casey in the courtroom requesting your time, please, at your earliest opportunity to convey the importance of my requests, hopefully to be completed. Okay. So I don't know what they're going to do there. I don't know what the laws are, and I think that what will likely happen is the judge, and the jail are going to defer with respect to the internet, and probably they might give her an allowance so that she is the phone calls are not collect. She has, like most people have, the card that keeps a balance on it or whatever. And all that would be required would be for the person to accept the call. They're not credited, they're not billed for it because they say prepaid on them. That might be an option. And then they might grant her funds for that. As far as internet access, I don't see them doing that. I think what they're going to say is you should probably defer that to maybe your private investigator and contacting witnesses, etc. I just don't think they're going to give her access to the internet, but they might. I don't know. And with that said, before we close for the day, due to the fact that I got 100 likes and I said I would, and I will, here we go. Gypsy and Aunt Brenda. I'm on a high right now. Y'all can't bring me down. And the D is fire. Okay, baby, that is completely and entirely inappropriate. I don't know what you're doing. And by the way, when you're alive over there on them tickety talks, I'm going to need you to put on your bra. It's inappropriate for you to be live on them tickety talks without your bra on, baby. Okay, Gypsy Rose? Here y'all go. There it is. And I'm not even exaggerating. Old Gypsy Rose was on the tickety talks this morning doing a get ready with me, not wearing a bra. So there you have it. All right, you guys, I'm going to give y'all the intro. I'm going to bid you a fond farewell and adieu. I don't know I know that I'm going to be live tomorrow on Patreon with West Memphis 3. I'm going to be reading from Terry Hobbs' book, Box Full of Nightmares. I've got some stuff also I want to show you, some videos and stuff like that I want to show you guys. So if you are not already a Patreon member, please consider joining. I have to say that I was quite consistent with the Gypsy Rose situation. I went live and did each Saturday morning or each Saturday at noon, and discuss the episode, recap all of those things. I will be as diligent with going live there for the West Memphis 3, and I'm also got some videos and stuff that I'm working on for the Real Housewives of Orange County, if that's your bag. It is getting quite messy, and I cannot wait to talk about all of that with you. So thank you guys all for being here. Welcome to the new members. I appreciate your support immensely. I appreciate you guys all being here. Thank you so much. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious. Finish her.
Minutes later.
all do a little mad sometimes.